Three gunshots. 3 gunshots. And that's the end of the video. So what do we have here? We have this homeowner comes at the door to confront a DoorDash delivery guy. It looks like he's got something shoulder strapped to him, but he's using a handgun here. He steps out the door. The first thing he does is cycle the slide. Well, why would you do that? Why would you do that? Why isn't, if you're afraid you're going to need a gun for personal protection, why isn't there a round in the chamber before you walk out of your house? I mean, if you think that guy might kill you, a gun without a round in the chamber is not going to be very helpful. But he steps out, cycles the slide on his pistol, and then fires around into the ground beside him. A warning shot, I would imagine he would call it. That's the first right there. Bam, bam. Now, he seems to be living in a pretty rural area. Maybe you can get away with a warning shot without getting charged with reckless endangerment, felony reckless endangerment. And this guy was not charged. He was charged with a number of felonies, but not felony reckless endangerment. But in a community, you just fire a warning shot at the ground, you're risking the life of every innocent person in that neighborhood. You don't know where that bullet's going to go, whose life it might take. And there's no justification for firing a warning shot ever. So he fires that warning shot there. By the way, notice that at this point, the DoorDash guy, I'm just going to call him the DoorDash guy, is already in his car. That car in the distance. What imminent threat does that DoorDash driver represent in his car? And by all appearances, he's getting ready to leave. The car backs up. This guy decides to fire a second shot. Oh, is that? No, I thought that might be a piece of brass, but it's just a bug flying through the air. There's a second shot right there. What is this guy thinking of? And then the car backs up a little bit, goes to drive away again, is driving down the street, and our homeowner fires a third shot, looking directly at the car. I mean, these are not warning shots now. I don't know how much of an expectation he had of hitting anything. It's not that easy a shot with a handgun. And the driver drives away with a bullet in his back. A bullet in his back. So this is a picture of the homeowner. That's him, John Riley. By the way, it turns out he's not only a highway superintendent in this town of Chester, New York, he's also an FFL. He's a federal firearms license holder. This is an image from the DoorDash guy at doing an earlier delivery. Now, I will say, I'm not going to bother playing this video for you because it's 1.5 minutes long and nothing much happens. But it's notable that the driver, apparently he stopped at some other house and he's holding up his phone, which appears completely dead, this guy. And he appears to be asking for assistance from the homeowners. Now, some strange dude comes to your door and he can barely speak English. I mean, I can barely understand what this guy is saying. It may well have made the homeowners nervous. They certainly didn't help him. And I can't blame them for that. But it seems to me like this DoorDash driver is driving around trying to make deliveries. He's got a dead phone. For whatever reason, he can't charge it in his car. And he's lost. And I can tell you, I've lived in some of these upper New York State communities. At night, it's really dark. There's like no street lights. It's not hard to get lost if you're not familiar with the area. And of course, the phone would solve that problem. But if your phone is dead and not working, I can see this guy being at loose ends, this DoorDash driver being at loose ends. Now, this John Riley, he's in a lot of trouble. I mean, he's been hit with really serious charges, including, this is from a New York State report. I know the font is real small, but I'll cover them in more detail. Assault in the first degree, a Class B felony. Criminal possession of a weapon in the second degree, a Class C felony, and criminal possession of a firearm, a Class E felony. Now, these firearms violations, New York State is a gun control state, a hard gun control state. They've got all kinds of crazy gun control rules. They punish violations severely, and we'll take a look at what those criminal charges could carry in terms of sentences. This guy is looking at a lot of time. So, assault in the first degree, the Class B felony, 5 to 25 years in prison with a 5-year mandatory minimum. And what is assault in the first degree? It's simply with intent to cause serious physical injury to another person, he causes that injury by means of a deadly weapon. Is there any rationale under which this homeowner did not do that? I don't see it. I mean, unless he can justify it as self-defense, defense of property, defense of highly defensible property. We'll take a look at that in a moment. But if he committed this conduct. So unless he has some legal justification, he's looking at a 5-year mandatory minimum for assault in the first degree. And by the way, like many states, especially gun control states, New York State has a very healthy firearms sentencing enhancement that's tacked on top of whatever the underlying criminal sentence would be for the criminal offense. So he's looking at 5 to 25 for the Class B felony with a 5-year mandatory minimum. But because he used a gun as a dangerous weapon, he's potentially also looking at an additional 25 years in prison, potentially 30 years in prison for firing that shot that hit that DoorDash guy in the back, unless he can somehow justify it. We'll take a look. We'll talk in a moment about some of the possible justifications. In any case, none of the self-defense justifications are going to help him with the weapons violation. So criminal possession of a weapon in the second degree, Class C felony, good for 3.5 to 15 years. 15 years. Now, what does this even mean, criminal possession of a weapon? Well, there's lots of weapons in New York State you're just not allowed to own under any circumstances. And if you're in possession of one of those, well, you violated the statute.
Did you know that in all 50 states, self-defense law, not gun law, but self-defense law, uses a simple 5-element test to see if your use of defensive force was legally justified? And that same test applies no matter what state you're in or what tool you use to defend yourself. If you're missing even one of those required elements, however, you've made yourself an easy conviction for an aggressive prosecutor. My name is Attorney Andrew Branca, and I've worked more than 30 years as a self-defense attorney. Every state has seemingly endless, complex pages of laws regarding self-defense, so complex that many top criminal defense attorneys rely on my expert analysis to help win self-defense cases for their clients. If the legal code is that complex for lawyers, how can a citizen gun owner expect to know or even follow the law, especially when a life or death situation has triggered a massive adrenaline-fueled mandate to make that fight or flight decision right now? It seems daunting. Yet I created a simple but powerful framework that has allowed me to serve the legal community and countless American gun owners to simplify this legal complexity into just 5 elements of self-defense law. And you can learn my 5-element legal algorithm I use to consult on and win with the top criminal defense attorneys all over the country to protect law-abiding, gun-owning citizens from making innocent legal missteps that land them in prison. Now, with a simple read or listen, you can install my 5-point legal framework so it acts as a sort of muscle memory defense to protect you from losing your rights when you choose to defend innocent human life. Click below to get the latest edition of my book, The Law of Self-Defense Principles, for free. I ask only that you help cover the shipping and handling cost to get the book to you.
Now, this guy is reportedly an FFL, a federal firearms licensing dealer, and sometimes those guys get a little crazy and they start obtaining weapons in the delusion that their FFL entitles them to weapons that state law prohibits. I expect what we'll find is that when the cops searched this guy's house and they went through his weapons, they found a bunch of weapons that were not legally possessible under New York state law and hit him with that offense. And then criminal possession of a firearm, Class E felony, good for another 1.5 to 4 years. And again, this seems to apply to weapons that, you could, if you lived in Tennessee, you could own it just fine. It's not a problem. But New York State, either they have a firearms roster, or one of the things New York State does, for example, that's really weird, is every firearm you own, the serial number has to appear on your permit, your firearms permit. They literally print it on the permit. And if it's not on there, you've committed a crime. So he has all that time. Of course, the big one's the assault in the first degree with the 5-year minimum mandatory. But even if he were to be justified in that, they're still going to nail him on the criminal possession of the firearms charges. the worst of which is good by itself for 15 years in prison. So pretty grim, pretty grim. What are we looking at here in terms of possible justifications, legal justifications for this use of force? Well, of course, one justification that would normally be available if you shot somebody would be self-defense. The legal justification is self-defense. What's required for that? Well, you have to have had a reasonable perception that you were facing an imminent unlawful threat of deadly force harm, death, or serious bodily injury. Is there any of you of these facts when this John Riley is firing these shots at the car that anyone could have had a reasonable perception of an imminent threat of unlawful deadly force harm at the moment those shots were fired? I don't see it. I don't see anything close to that. Another possible justification might be defense of highly defensible property. You're protecting your home against some kind of forcible intruder. Well, New York State does allow you to use deadly force upon a burglar in your home, which somebody's made unlawful entry for the purpose of committing a crime within the dwelling. That's a burglary. New York State has a specific defense of home against burglary statute. This guy was in his car driving away. He wasn't committing a burglary. New York State also has a provision that allows you to use deadly force to prevent arson to your home. If this guy was there with a gallon of gasoline and a lighter and trying to set fire to John Riley's home, John Riley could use deadly force to prevent that arson from occurring. Nothing like that was happening here. There's no defense of highly defensible property here. There's no evidence of any attempt by this guy to make a forcible or unlawful entry into the home. What about simple trespass? This guy presumably came up to John Riley's door, rang the doorbell. Somehow John Riley became aware he was out there. Let's presume he walked up and rang the doorbell. Well, if you're on someone's property without license, you're committing a simple trespass. Fair enough. Can you use force to remove a simple trespasser, someone who's on your property but not otherwise committing a crime? Of course. But you can only use non-deadly force to remove a simple trespasser. And in any case, folks, when you have a path up to your door and you have a doorbell, unless someone had to go through a locked gate or past no trespassing signs, there's an implicit license for people to come up and ring your doorbell. That's why the doorbell exists. So unless you have a no trespass, no soliciting, or some kind of barrier they would have to have overcome, it's not even a simple trespass. And you certainly can't use deadly force to remove a simple trespasser in any case. So I just don't see any justification for this. And by the way, I will, for the law of self-defense members, I'll put links in the blog version of today's show where you can access the various penal code statutes this guy's been charged with violating. There's the gun offense and there's the second gun offense. And of course, here is the assault charge.
Thanks for watching this highlight segment of our full-length Law of Self-Defense live stream. If you enjoyed this content, make sure to give us a like and subscribe for more expert analysis on politics, law, and how to be hard to convict. And to watch the full-length episode of this show, just click right here. Stay safe.